Hi, I'm Kurt Doolittle for the Proprietarian Institute of Natural Law. We are continuing our talk on European group strategy. I'm here with Dr. Brad. Dr. Brad, can you say hi?
Hello.
And thank you again, Dr. Brad, for helping me go through this work. I wouldn't be anywhere near as good without your assistance. This is the third section of European group strategy. In the first, I covered our origins, which is using the analogy of pirates, showing that the only way to govern pirates is democracy. They formed a democratic polity, they elected their captains or generals or kings, and they elected their quartermasters, or what we would consider judges or maybe sergeants. And they built their society as was the only way possible. There's no other way of doing it. This has to do with more technical issues like the principal agent problem, which I'm going to avoid going into at the moment. And so then I tried to show how there's no difference between the origin of the pirate method of self-governance and the step method of self-governance. And from that position, I try to explain our history of rule of law and democracy evolved very naturally out of necessity, whereas Brad has reinforced lately, it's just all deterministic. So I try to make the point there that it's not that we invented democracy so much as that democracy was necessary and it invented us. And so we became anchored in our first institution, which we call democracy, or which we could call rule of law, or which we could call many other things, but it's really just the only possible way of organizing entrepreneurs who have to take on risk in order to pursue an outsized reward. In the second part, we went over the foundation of rule of law because, of course, we want an analytical description of it. Now, at the risk of adding confusion, again, there are three parts to this section: origins, legal foundation, and trifunctionalism. In this section on trifunctionalism, we've broken it up into 6 videos. The first is the ternary logic of the jury and the ternary logic of rights, then the ternary logic of government, then the ternary logic of legislation and the ternary logic of the judiciary, then the ternary logic of trifunctionalism as a macro strategy, and the laws of the universe and the tragedy of those laws and our continuous adaptation to them, and then the virtuous cycle of the adaptive velocity and the science of the OODA loop as continuous adaptation. And lastly, the ouch of our success, our weaknesses and our failing, and lastly, the future. In today's discussion, I'm going to cover what's trifunctionalism, and to do that I have to hopefully remind you of one fact, because at this point we've covered such a broad range of material, the underlying purpose of what we're doing and the method might be lost by now. So the method is continuous recursive disambiguation in effort to find first principles and to develop a logic of first principles to produce a formal logic and operational logic of first principles. From that, we could produce a falsificationary logic of every aspect of human thought. Now, in that developing of first principles, I start out with a basic argument that in two opposing forces, there will be a stable state emerge, and a minority of stable states. And then we will continue to evolve stable states from each of those stable states, and in this way, the universe creates all this complexity by this search for stable states. Anyway, so the same thing happens when we apply it to psychological and social factors. So just as there are a male and a female, and we create stable states in the middle, or the male and female sexual reproductive interest, we create stable states through cooperation, then this idea of ternary logic applies throughout all of our existence, and it applies, and it's primarily what I'm always expressing here as even with the fact that there's 3 methods of coercion or so many sorts of governments. That's because these are all derived from the underlying binary problem of male and female interests and cooperation necessary to bring them about, and the natural distribution of our traits, because while we can have the extreme male and the extreme female, we also have, most of us are some admixture of the two, and we express our bias toward the male and female strategy at different points in our lives and under different circumstances. So today we're going to walk through trifunctionalism, and I'm sorry if I had to give you that broad overview to start with, but I didn't want to come into this subject without reminding us of the foundations of what we're doing, which is ternary logic, and developing first principles, that most first principles were reduced to some sort of ternary logic, and that the European civilization emerged under rule of law, that is, rule of law, or what we consider democracy, in the absence of authority, and this brings us to how do we explain all that with ternary logic. So hopefully I've done enough of an intro that I won't lose everybody from here forward. All right, so we're going to go through trifunctionalism in the context of European civilization. And I'm going to start out with stating that we, again, rule of law is a via negativa set of rules. In other words, we simply look at what you can't do, and anything else is fine. It's the same thing for leadership, is that there are things leadership can't do, and outside of that, leadership can do it. So via negativa, we're building a box around leadership that limits them to what's in the mutual interest of the group. So I'm going to start at the bottom with the jury, because that's the origin of the democracy. And again, I'm not saying democracy like we think of it, which is in the postmodern sense, like universal, meritless democracy. I'm using democracy in the sense of citizen shareholders at the political scale, private corporate shareholders at the commercial scale, or in this case, at the entrepreneurial scale, those people who have a demonstrated interest and are taking demonstrated risks. So we're starting out with this jury under the constraint of which is democracy is delineated by those who have contributed and are taking a risk with their capital. So the logic of the jury is not just guilty, not guilty, which is what the judges want us to believe, but it's guilty, not guilty, and nullified. So one can be guilty, found for the plaintiff, or found for the state, not guilty, found for the defendant, and nullified not guilty, meaning it's a bad law, or nullified guilty, which is a insufficient law, a bad law, or a weak court process. In other words, the jury is the end decider. This is a little bit of a problem. In other words, this is where democracy begins to fail, and why democracy is only useful for the selection of priorities among people with common interests. And it's why democracies fail when they reach the scale of people with heterogeneous interests, especially when those heterogeneous interests cannot be solved by market means. So that's the logic of the jury and the logic of democracy, is that the limits of democracy are demonstrated interest, demonstrated risk, demonstrated reciprocal warranty and liability, and the limit being the commonality of those interests. This is why I always say that democracy is useful for selecting priorities for the production of commons, given the scarcity of resources that can be diverted to the production of commons. But democracy is insufficient means for providing a means of resolution of difference in the selection of commons that are in conflict. And this is, of course, the problem of diversity, in that the commons necessary for different groups, given their ethnic and demographic distributions, is impossible. And that's why you try to keep states as small as possible, because you have the least power distance, you have the greatest homogeneity, and the greatest common interest. And all that scale does is allow the state to manipulate you, because now that you're beyond the range of democratic decision making, you have to be lied to. After the logic of the jury, we have the question of the ternary logic of rights. Of course, we claim rights under these contracts of natural law. We have obligations. We can't have a right that doesn't have a reciprocating obligation, or it isn't a right. And we have inalienations. And this is what's weakly attested or executed in our Constitution, is this ternary logic. We claim we have rights. However, rights must have obligations, and it must have inalienations. So an inalienation is you can't escape insurance, warranty of insurance, and liability for insurance and warranty of your rights and obligation and others' rights and obligation. This is where the right to bear arms comes from. Not only is it the only way of preserving a democracy, preventing the rise of authoritarianism, which is discretion rather than rule of law, which leaves all discretion to the jury. Not only have we've stated rights, we've failed to always state the obligations, or we've implied those obligations, and the common law is fine about it. But when we talk about inalienations, we are saying it in the context of the state can't deprive us of some right or obligation. Yet we have people who seek to escape those obligations and while having those rights. And so this is how democracy gets out of hand, is that if you're not insuring other people, then it's not a democracy. In other words, unless you're taking on the inalienation of defending that democracy, you're not engaging in democracy, you're just undermining it. In other words, you're escaping payment for the conditions that make your rights possible. So under reciprocal exchange, insurance, guarantee, and liability for that guarantee of self-determination by self-determined means, which in turn requires sovereignty and demonstrated interests, which requires in turn reciprocity in display, word, and deed, were limited to voluntary reciprocal exchanges of demonstrated interests, free of imposition upon the costs of the demonstrated interests of others, thus limiting us to markets and association, cooperation, reproduction, production of goods, services, and information, and production of commons by the government, using equally of goods, services, and information. The point here is that all rights must derive from sovereignty in demonstrated interest, insurance of that demonstrated interest, liability for that insurance, and that we limit ourselves to reciprocity in display, word, and deed in all matters private, corporate, and common. We have to include the terms of the right to reciprocity, obligation to responsibility, and inalienation to cover insurance and defense. So any right that's not expressed as all three of these can't constitute a right because it's incomplete and irreciprocal. So the failing of our Bill of Rights is that it doesn't articulate what I'm stating here as a necessary logic of the possibility of having rights. And lastly, it must include punishment for failures of responsibility, insurance, and defense. Of course, my Constitution reforms this. So we have a ternary logic of the jury, and we have a ternary logic of rights. And most of our philosophical history is based on rights in the absence of other obligations and alienations. But in order to prevent people from not engaging in all sorts of crimes against the commons, we have to articulate rights, obligations, and alienations so that people can't even give away their rights. In other words, it's a crime to try to give away your rights because you're trying to give away your obligations to others, and you're trying to give away your responsibility for ensuring the rights and obligations of others. In other words, if you don't take up all three, you can't have that right without engaging in a crime.
I like that.
So what I hope to have covered in this slide is the first two steps, starting from the bottom up, the ternary logic of the jury and the ternary logic of rights. And the next section will handle the ternary logic of government.